Okay, well, let's go ahead and get started. Welcome again, everyone, to our July 2026 webinar. Thank you for joining us. I'm Ann Massey Badmus with Badmus Associates, and today we are going to talk about the EB-5 Immigrant Visa Program, Immigrant Investor Program, as it stands right now in summer 2026. So I want to say at first that why we scheduled this particular session because EB-5 has changed more in the last 6 months than it did in the 2 years before that. So in March, USCIS overhauled the way it processes in terms of timing investor petitions. And in May, the USCIS also issued a policy memo that talked about adjustment of status, not just for EB-5, but for all potential applicants. And then on July 2nd, the Department of Homeland Security, which is the leading agency for USCIS, released a 358-page proposed rule that could change or reshape parts of the EB-5 program going forward. So if you looked closely at EB-5 last year, if you were looking at the program then, some of what you think now might be out of date. So over the next 45 minutes or so, I'm going to walk you through what actually happens today and what we might expect in the future. Okay, so sorry, trying to move on. So here's what we're going to cover. We're going to start with the fundamentals of how EB-5 works, in particular, what amount of investments are required, the two ways that you can structure an EB-5 investment, the order in which filings happen, and how you prove where your money comes from, other source of funds. The last piece will take up about 2 slides because source of funds generates more requests for evidence than any other part of an EB-5 petition. Then we'll also cover the new USCIS processing rules that took effect in March regarding the EB-5 program. Talk a little bit about, next we'll talk about the EB-5 or the Visa Bulletin, what it is and what it means for EB-5. And after that, we'll talk about the as I mentioned, July 2026 proposed rule. And then we'll close with the dates that you should be looking at in terms of deadlines and timelines to drive your decisions. So we're going to hold questions to the end so we can get through all of this. However, you are invited to go ahead and put your questions into the chat, and we will look at the chat towards the end in terms of questions and answer those. So we should have a good amount of time for questions as well. So 2 quick things before we go further. First, on privacy, when we do get to the questions, please ask your questions in general terms and try to avoid sharing personal details or identifying information. Keep in mind other attendees are here and these sessions are recorded. So if your question is very specific to your situation, we do encourage you to contact us for a private consultation rather than post it here. Secondly, on the scope, this educational session is educational. So it is for information only. It is not to be considered legal advice for your particular case. It is definitely not investment or securities advice. We do advise clients on immigration petition, but we cannot tell you whether a given project is a sound place to put your investment. So keep that in mind. And as well, everything that we talk about today is as of July 2026. Like all areas of immigration, things can change pretty quickly. So keep that in mind as well. So let's now talk about how EB-5 works. There are currently 3 numbers that you need to know about in terms of investment. The lowest amount of investment available is the $800,000 minimum, that if you invest in what's called a targeted employment area, meaning that's either a rural project or a project in a high unemployment area or some particular qualifying infrastructure project that the government has interest in. You also have the standard investment, which is the $1,050,000 is the minimum for anything that's outside of that targeted employment area. And regardless of which investment you choose or which amount of investment that you make, the investment has to create 10 jobs, full-time jobs. And so regional, now only with regional centers, which we'll talk about more in depth, can't, if you invest through a regional center, then those 10 jobs can be created by what's called indirect or induced jobs, meaning that you're not directly, that those jobs could be done by contractors, for example. Now, these amounts that we're looking at are not permanent. The Reform and Integrity Act that was enacted a few years ago, and actually in 2024, built in an automatic inflation adjustment. So as you can see, there is an inflation adjustment that is expected on January 1st, 2027. And there's also a proposal for a third tier of investment that we'll talk about in detail later. So the practical takeaway is that, the numbers are not locked in. There is a real reason that people are trying to file this year rather than next year. And this is one of those reasons as well. Okay. Now, there are two investment structures. As I mentioned earlier, there are two ways actually to invest in the EB-5 program. And so the direct investment is meaning that you, as an individual investor, you are the only investor in a project. You're a standalone investor. So you're going to put money into a business that you control and that you're actually going to run. So this direct investment is on structure, does not really have any sunset or limitations in terms of deadlines to apply. So if you're going to be a direct investor, the deadlines that we refer to in terms of September 30, 2026, which we'll talk about later, would not really apply. But when you are a direct investor, you must be aware that only direct jobs count, meaning that the 10 jobs that you must create have to be actual employees, full-time employees on your payroll. So it is an operational burden that rests on you. Now, the regional center, which is probably the great majority of EB-5 applications, means that you file a form I-526E, where you're making a largely passive investment into a project sponsored by the USCIS designated regional center. The advantage is that it's indirect and induced jobs are counted towards that 10 jobs. There can be multiple investors into a regional, there are multiple investors into a regional center. And that's why the overwhelming majority of EB-5 investors go this route. But there's a trade-off that could become more significant this year. A regional center petition depends on project level filing called an I-956F. And that requires that is approved. So under the new rules, your petition's timing is now tied to your project filing. And the project filing is done by the regional center. So the structure that you choose determines not just how jobs are counted, but who controls your timeline. And so that brings us to the filing sequence. And so there are 5 steps in this order. If you are applying for a regional center, then the first step would be applying through investment into a regional center. Then the first step is the form I-956F, where your regional center files the project application, and the USCIS must have approved that first or decided that first before you can go to step 2, which is your actual investor petition if you are the investor. So you as the investor either file an I-526 if you are doing a direct investment, not a regional center investment, or the I-526E if you're going through a regional center. So this is where when you file the I-526E or I-526, you are establishing your priority date, which is your place in line and which proves your source of funds. So that is very key. So step 4 is the form I-485 to adjust status, meaning this is the actual what we call green card application, because the approval of an I-485 means that the green card is issued to you. If you're not eligible for I-485 adjustment, then the other option to actually get your green card, to finally get your green card, is through processing at the U.S. Embassy, or what we call consular process, where you're issued an immigrant visa so that you can come into the U.S. with permanent residence. And then step 5 is in all cases, whether it's regional center or direct investment, you are required, you will initially, if approved for the green card, receive a 2-year conditional green card, meaning it's a temporary green card, and that means, or temporary permanent residence, which means that you would have to file an I-829 application to remove the conditions, and in doing that, what you're doing is you're confirming that you did indeed invest, or the investment did go into the projects and the jobs were created. So if you are proving that at the I-829 stage, once that's approved, then you actually get your final permanent residence. So again, if you're going through a regional center in 2026, it's a lot of times people kind of assume that their own filing date drives their timeline. But if you're using a regional center, it's very important to know or confirm that the I-956F has been filed by the regional center before you proceed with your application. So really important, as I mentioned, is, and the great bulk of your application as an investor would be proving where your capital comes from, where your investment comes from. That is what we call source of funds. And as I mentioned earlier, this is where the most requests for evidence or even denials come from, and source of funds are not, or if you do not provide sufficient evidence of source of funds, then it is a big issue for your application. So first, an important framing point, there really is no approved list of acceptable sources. So we do list some of these, but it's not necessarily an approved list. This is what the USCIS has accepted in the past, but USCIS is not asking what kind of income you have. What they're really asking for is, was the money obtained lawfully, and can you show or trace it? Can you show where it came from? So easiest types of records to produce for that proof of lawfully obtained funds would be, of course, your salary and wages. So your tax records, your W-2s, 1099s, whatever you receive to prove your wages. If you are a business owner already and you obtained your funds through business profits, you want to be able to prove that you actually did operate a business. Those business tax returns, financial statements are important. If you are obtaining your funds through sale of any type of assets, real estate, inventory, any equipment, anything that you are using to sell and receive cash in order to invest, you need to provide proof of that as well. And then EB-5 investors can be gifted the money. So if someone is so generous as to give you a gift in order for you to invest, then it's important that you be able to show how the donor, the person who gave you the gift, obtain their funds. So they would have to prove many of the things like their salary and wages, business profits, sale of assets. How did they obtain their funds? We must not only trace your funds, but or the gift that you saying that you received the gift, but we must also trace how that donor or the benefactor gave, how they obtained their funds to give you that gift. If many times we're asked about getting a loan, so it is possible to be to use a loan to finance the program, but the loan has to be secured by your own assets. It can't be secured by the EB-5 project, which the EB-5 project, of course, will have assets because it is proposing to build something related to the project, whether it's a call center, whether it's a bridge, or whatever it is, real estate in itself. So the loan that you receive cannot be secured by that project itself. It has to be your own personal property. And then of course you have to document how you actually acquired any of the assets that you are using. So for example, your home, of course, if you have a home that has enough equity or has equity that you're going to use as a loan secured against your home, you can use that as well. But you have to show that. So it's two-step proof. You have to prove the loan and you have to prove the asset behind the loan. So loan funded petitions most often break down on that second step. So it's very important that you have that asset. One more thing I wanted to say about the gift part of it. A gift is a legitimate source, as I mentioned, but a signed gift letter by itself proves nothing. So again, you have to be sure that you have the earnings documented to the same standards. The last thing, of course, is inheritance. If you inherit funds that you're going to use to invest, you have to prove that. You have to have the information there. Probate records, any statements that are available. So you want to make sure you provide that as well. Now, one last thing that it's important is that most regional center projects charge an administrative fee or a subscription fee on top of the $800,000 investment, for example. So that fee also requires that you show, because you will have to pay that fee as part of the requirements for the regional center. So you also have to budget for that fee and also show not only the $800,000, but if it's $100,000, $80,000, whatever the project or the regional center fee is, you have to show that how you got those funds as well. So the entire amount of the investment, the $800,000 plus any fees, must be documented. So proving the source of funds. So if you take one concept from this section, make it this one, the USCIS is asking two separate questions and you have to answer both. So source is how the money was lawfully earned, whether by you, by a gift donor, or by a lender. So the path is how that money moved, and the path is how that money moved through every account. So how was that money, like it went, if it was a gift, for example, what account did it come from the donor, and how was it received by you into your own account? So you have to provide the bank records to show exactly how the money came to you. So it's very important that you understand about that. So both must be documented. In addition, the investors always have to prepare the source side. That means you have to show you how you earn the money. And so, for example, the most common gap you have is exactly when you predict that funds pass through a relative's account or a third-party exchange. And that might be really difficult to show. So it's extremely practical, but sometimes because of government regulations and different issues other than the EB-5 program, it may be difficult. So again, every single step of the way has to be shown. In addition to that, we have what's called a core documentary record, which forms the source of funds, regardless that you would have to provide, even if you were gifted the funds, you yourself, as well as the donors, information has to be presented. And so what they're looking for usually is for 5 years of tax returns, personal tax returns if you have a business, and of course business tax returns as well. They look for any kind of litigation record that you have, 15 years litigation and administrative, so lawsuits basically against you, covering if you have any judgments, any pending criminal and civil matters, any government administrative proceedings. They're going to be looking at that, whether it's in the US or overseas. They want complete records, again, for every transfer along the path, from going from how you receive the funds into the escrow to the regional center, because the funds do have to be deposited to the regional center before you can even apply. You cannot hold those funds until waiting you cannot say, I'm going to hold those funds until I receive my approval. No, actually, you have to put those funds into the escrow for the regional center before you will be able to even apply for EB-5. So one practical note, just as we close this section, assembling all this documentation, although it looks pretty simple on the screen here, it does take quite a bit of time. It can take usually weeks, sometimes months, depending on where your transactions are, especially if it's crossing internationally, those types of things. So before you select a project, even before, if you have already, that's fine. But in any event, best case is to look at your path of investment, source and path of investment, look at those and start gathering that information as soon as possible. So now let's talk about the foundation. Now let's look at what's changed this spring, starting with how USCIS decides how or when they're going to work on petitions. So when we talk about inventory management, what we're talking about is the inventory of applications that the government is getting for EB-5 and how they're managing those numbers, those applications that they're receiving. So according to effective as of March 30th, 2026, USCIS now has a specific way of processing applications. So again, it announced in February, and I want to announced this rule in February that took effect on March 30th, and I want to be precise about what it is. This really just changes the way the agency manages its workload. So it is not really a change in law. It doesn't really change anyone's eligibility, but it very importantly changes the timing significantly, which is, of course, important to everyone who's investing or applying for EB-5. So there are 4 elements to this sequencing that the USCIS is doing. First, they're going to look at the project first. So USCIS will not review an I-526E, assign it for review, meaning it's not going to pass it on to an officer to review until it has actually decided the associated I-956F. As I mentioned before, the I-956 is the project application. So they have to be sure that they have reviewed that first and make sure that's approvable. Secondly, they're also going to have, or they have a rural priority queue. So that means rural petitions that are based, where the project is located in rural areas are assigned for review first. In first out, first order. So they're going to look at all as the rural applications come in, hopefully they will look at those who come in earlier rather than those that come in later. So it should be first in, first out order so that the agency can use the reserved rural visa numbers for each fiscal year, because there's a very specific carve out for those particular types of visas. Third, they have sub-queues by category. So remaining petitions may be grouped by rural, high unemployment area, infrastructure, and unreserved. So again, rural has priority. Anything after that, they're looking at was going to be high unemployment, infrastructure, and unreserved projects. And then fourth, there's first in, first out within each queue or sub-queue. So your filing date determines your position inside a queue, but it doesn't determine your position across the queues, because again, if you have a rural-based petition, then you're going to be in higher priority. So here's what you should know. So basically what comes from this is an older filing date no longer guarantees an earlier review. So you may have people that are getting their EB-5s approved, EB-5 petitions approved earlier than those who came in later. And it's because basically this particular sequence that the government is using. So what does this mean in practice? The numbers show that basically prioritization is working. In the past, we would see I-526 applications or particularly I-526E applications taking years and years, like the queue was like 90 months, that kind of thing. It was absolutely ridiculous. But apparently since this process has started in March, according to the numbers here, the rural I-526 petitions are averaging roughly 8 months to approval, compared with 11 months for the high unemployment area petitions. And the rural cases account for nearly 81% of all of the cases that have been adjudicated in the reserve pool. So despite only having slightly more receipts than the high unemployment area. So rural fast lane is real at the petition stage. So this very same prioritization that clears rural petitions quickly is what will also cause those rural visa allocations to be exhausted. As we'll talk about in the next portion of this, as far as visa numbers are concerned and what that means, as more and more applications get approved, then the limited number of EB-5 visas are going to be used. which means it's going to take longer for some in order to get the actual green card approval. So approving petitions faster, the EB-5 petitions faster does not create more visas. There's only so many rural visas available each year. And so moving investors to the front of the line moves them to the front of the visa line where that supply is fixed. So those fortunate investors are able to get one of those visas, but as a result, it may cause investors later to take longer to get those visas. So independent analysts are projecting that something in the range of a 4-year wait for rural investors with priority dates after January 2025, and that would be considerably longer for those who are China or India because of the per country limit. So it's important to know that even though we do want to have speed to the approval of the I-526E, it's not the same thing as you getting a green card. Visa, green card, same thing is what I mean, in 8 months. So what we're just talking about is the petition being approved. Does not mean you're getting a green card in 8 months or you're getting a green card in 11 months or so. So keep that in mind. And so why are we saying this? Because of the Visa Bulletin. So what we want to talk about is what does the Visa Bulletin mean and what it doesn't mean. So right now, as we stand as of June, actually it's even currently sorry, that slide is a little dated, but it's as of July, basically you want to look at what the Visa Bulletin is saying as far as the EB-5 category. So currently the rural petitions that set aside, that 20% set aside, is current for all countries. The high unemployment is current for all countries, and infrastructure is current for all countries. So those are those priority levels of priority queues. If you're not in one of those priority queues, then it's current still, but it's backlogged for India and China. And if you're looking to find whether you can adjust status, typically the government, USCIS, determines every month which Visa Bulletin chart they will use. There's a chart for final action and there's a chart for dates for filing. Usually the final action chart is slower than the dates for filing, but the USCIS will determine which chart they will use. Currently, they're using the final action chart. Typically, or at least what we've seen in the past 4 or 5 years, they have in the new fiscal year starting in October, they have usually switched to dates for filing, which has given the ability for people to file their I-485s faster. So that's important to know. Okay. So what does current mean? Current, when we say current, as I mentioned on the previous slide, current doesn't really mean that there's no backlog. I want to try to explain how the Visa Bulletin actually works, because the word current seems to look really great right now for the EB-5 category. But what it means is that a category, EB-5 in particular, shows a cutoff date only when the number of fully processed applicants who are ready for a visa is more than the number of visas available that year. So a statement of current is really just about the pace of how the government is processing applications. It's not really telling us how many people are actually in the queue, or really giving a good projection of the future, what we can expect. Because if you've looked at the Visa Bulletin, you will know that sometimes it goes forward, sometimes it stays still, sometimes it goes backwards. So it's pretty unpredictable, because it really is kind of based on looking at how quickly the government is making approvals of immigrant visas or green cards. So sometimes the queue that is not really considered is that every investor is still going through the I-526E process, or I-52, and every investor whose project is still waiting. So we have those people who are still in the queue being processed. They haven't gotten to the approval stage, but they're in the pipeline. But that's not counted in the Visa Bulletin. The Visa Bulletin has no record of that, does not consider that when it's providing its visa availability. So right now, independent estimates, studies have been made. They believe that have put that more than 15,000 set aside investors are in the pipeline before you even add spouses and children, because spouses and children also take those numbers, those visa numbers as well. So if you look at that, a typical year makes roughly about 3,200, I'm sorry, set aside visas available, a very small amount. So you can see that there's probably still going to be quite a bit of wait for most people to finally get their green card because of this limited availability itself. Okay, so country of birth also makes a difference, of course. So as it relates to Visa Bulletin, as it relates to the queue that we're looking at, the processing queue. So it really does drive a great deal of EB-5 strategy if you are planning to apply, or if you're in the process, or if you are actually even in the queue. If you were born in China or India, the unreserved category, as I mentioned earlier, is backlogged. And the State Department has basically really flagged India's unreserved category as one where in the future it's very possible that we may see, because of the high demand, that there's going to be a retrogression or even unavailability. So and then the set asides are very, very important in that case, because it gives you a separate visa allocation. As I mentioned, that priority of rural, unemployed areas. Those are the areas that if you are in those particular set asides, you may have somewhat of an advantage. So you want to consider that as you're looking at your projects or determining which projects to invest in. But then again, we also see that a lot of that set aside area is heavily concentrated with investors from India and China. So it's really hard to kind of gauge that, but because everyone who is from India and China, or most everyone who's India and China, wants to be in those categories that are going to be faster, you're going to see a great number of people there, and which will also again extend the time to actually get your green card. So what I do want to caution is, again, though, don't just choose a project just because of a visa category, because it's important. It is a lot of money. So you don't want to just think about the visa category alone when you're evaluating projects. You want to be sure that you have some level of comfort that the funds will be wisely invested and not lost to you. So a weak project that is in an available category can be a worse outcome than a strong project that's going to be in a slower category. So keep that in mind as you are looking at investment in projects. Next, we're going to turn to the July 2026 proposed rule. As I mentioned, this is a new rule just issued. Now, it is not, I'm sorry, not just issued. The proposal has been issued, so it is not yet the law. But it is important to know about it, because more than likely it will, with maybe some revisions, become the law in the future. So on July 2nd, the Department of Homeland Security released a 358-page notice of proposed rulemaking, which is a requirement for agencies to, if they're going to implement rules that are going to change processes so significantly, they are supposed to allow the public to see that proposed rule and be able to comment on it. So its purpose, according to the government, is to codify the EB-5 Program Reform and Integrity Act of 2022 into formal regulation. So even though under President Biden, this law was enacted in 2022, and it has been actually used to process applications, it has not been officially, the official rules have not been generated or published, which is unfortunately quite typical with the USCIS. They may take many, many years to issue regulations or rules, even though the law is in effect and they're told to issue regulations, but they take their time about it. So it's not unusual that it is 4 years later and we're now getting a rule, even though they have been processing these applications since that time. But keep in mind with these rules, This is a proposal. Nothing takes effect until the final rule is published. And so there can be changes, as I mentioned, after public comments. Sometimes the government does make changes, depending on what they hear back from the public. But none of this really affects today in terms of filing. So as long as the rule is not into effect, we want to know about it, because I think, and if, it's important to know, especially if you're not ready to invest now or start their EB-5 application now, petition now, you need to know what could be a change in the future. So we'll talk a little bit about the comment. I just wanted to mention about the comment period. So we have until September 2nd to make comments. The rule is published online in what's called the Federal Register. So you can go there if you want to see the specific rule. I'll talk about kind of the basics of it. It's 358 pages, so I'm definitely not going to have the time to go through all of it here. But I want to give you some important parts of what is being proposed. And then you also have the opportunity to go and make comments about that on the USCIS website or the Federal Register website. So what is proposed? One important proposal is the proposed third investment tier. So as we mentioned before, there are two tiers of investment now: 800,000 for a targeted employment area and 1,050,000 for everything else. The proposal would still leave those amounts, but will add a third tier called which will be $1,400,000 for what's called a high employment area. So, of course, areas that are metro or suburban areas that don't have a high unemployment rate. That number gets attention, but it's important to put it in perspective. DHS, Department of Homeland Security's own data indicates that the majority of regional center investors already really invest in the targeted employment area, so that 800,000. For most people, this 1,400, I mean, well, 1,400,000 is probably not something that will be used quite a lot. So it's only relevant if you really want to have a project that is in a very a booming area, that has low unemployment, a metropolitan market. But if that's not your concern, then more than likely having this $800,000 tier remain is good. But it should be important to note that as stated on the previous slide, January 1st, 2027, there will be, or probably will be, an inflation adjustment. And so that is required by law. So that means the government will come out with new numbers. They may raise these numbers from 800,000 to a higher number to account for inflation. So keep that in mind as well. Another proposal is the 2-year sustainment rule. And actually, this is probably happening. This is really happening right now. As I mentioned, these are formalizing the rules that pretty much are kind of what's already going on as far as processing policy for the past 4 years. But it actually is pretty favorable for investors, because under the previous system, your investment had to be at risk through an entire process of throughout conditional residency, which means if you put in $800,000 today, filed your EB-5 petition, got approved for conditional residence, and then was applying to remove the conditions, that could be a 5-year process or more, which meant that you had to keep that capital in that investment for at least that 5-year period. You could not get it back. So under that approach, you could be, and in some cases, if you were in a backlog country, even if you hadn't gotten your green card, yet you were still in the process, that means you would have to keep that investment for 10 years if you were still in a backlog category. So you would, it could be more than 5 years. So in practice, well, most of the time, those projects would not last for 5 years. They would be completed, and the money would have to be reused and put into a second project and continue until you actually got your conditional residence, until you got your permanent residence. So what the new rule has proposed, or what the government has been doing, is saying that your capital must be at risk for a minimum of 2 years. And that is really a great rule. Actually, it's rare that we see it, but it's a great rule from the government, because what they're saying is that you must keep your capital at risk for a minimum of 2 years from the date it's made. So if you made it today, it must be available, made available. You put your money into the investment today. It must be for at least 2 years. It must be kept in that investment, and the required jobs. And if those 10 jobs have been created within that 2-year time frame, then you've met all the requirements, and you can actually potentially receive back your funds if all has gone well with the project, and still be able to proceed with the investment. Now, it still doesn't mean that you're going to get your money back in a year or at year 2. It just means that your immigration requirement has been met. But whether your capital is returned, because that's going to be up to the project, and that's not something that the immigration rules require the project to return your funds. It's basically saying that if you have kept the immigration rule is that if you kept that money there, it's created the 10 jobs, then you are approvable. But when you get your capital return is entirely up to the project and how it performs. So that's important to keep in mind, but at least you're not required to keep funds beyond the project viability as it was in the past. It also has protections for what's called good faith investors. The new rule does. So this is important if a regional center is terminated or is removed from the EB-5 program. So it's really important to know about this protection. Because in the past, if you had invested and your regional center is terminated, or a project was removed or debarred in some way, then through no fault of your own, that would be, that would have caused your application to either be denied, or even your conditional residence potentially denied as well. So there are 3 protections that are provided by this proposed new rule. If your sponsor is terminated, then you have a 180-day window to associate with the new sponsor. When we mean by sponsor, we mean the regional center. So if that regional center is terminated in some way, whether on its own or by the government, then you have 180 days to find another sponsor. Then, in addition to that, really important, your priority date can survive that transition. So you're not really starting over in that circumstance. And if you had actually completed that 2-year sustainment period, as I mentioned, and 10 jobs did exist, then you're still eligible, even if the project or the center is later reprimanded or sanctioned because of some actions on their part. So this is a real improvement over the program that was around in 10 years ago. But again, this does not protect, this only addresses your immigration eligibility. These rules do not protect your money. So if your regional center is terminated for fraud and you lose your capital, while your immigration is still protected, that there's not a protection, at least from the immigration side, as far as your funds are concerned. You may have to go through other measures, legal measures, in order to try to recover any funds, if that's possible. So let me finish up real quickly. I have quite a few left, but I'm going to go ahead and move more quickly through some of these. So one of the things I do want to talk about in the new rules as well is the source of funds. So now they're going to consider, not all, the government will now also or will confirm that digital assets, cryptocurrency can be a source of funds as well. But of course, you still have to prove that paper trail. You still have to prove how you obtained those funds and how they were lawfully invested, and all of the statements and things associated with that. In addition, the government is saying they're going to have tighter control over the regional centers. They're going to be requiring those who are promoting regional centers to register. So not only the regional center, but any marketers or promoters of those regional centers have to register as well. They're going to have higher compliance requirements or compliance cost and penalties associated with those regional centers that are not compliant or have in some way violated the rules as well. Then this is not so much related to the new rule, That was the last slide is pretty much all I'm going to talk about as far as the proposed rule. But as far as as I mentioned earlier on adjustment of status, what we saw in May was a new policy memo, which is still kind of unclear. We don't know exactly how we are seeing some things come through as far as how they're actually implementing the policy and the rules in the memorandum. But it is important to know, because if you are applying for adjustment of status based on your EB-5, that this policy memo, which is issued, does say that the government can review has higher discretionary review of adjustment of status applications. So this is really directly relevant to any of you who are already in the U.S. on an H-1B or an L-1 or an F-1 or some other legal status. If you're planning to adjust status rather than do the immigrant visa at the consulate, you can still file your I-485 concurrently with your I-526E if the priority date is eligible, if the visa number is available. You can still get your EAD, advanced parole from the filing, and consular processing still remains an alternative, but it is potentially harder. It depends on each individual circumstance, because the officers have so much more discretion to deny an application, even if you have met all of the requirements for the adjustment of status application. So really, when you're looking at adjustment of status, you do want to discuss with your attorney, looking at all the potential factors in your case, whether or not you have any adverse factors that could be potential for denial of an adjustment of status. So lastly, before we open for questions, I wanted to talk about the deadlines. So we have some deadlines. Many of you probably heard about the about the grandfathering deadline of September 30th, 2026. And I want to clarify what that is. It is basically a deadline where petitions filed on or before September 30, 2026 receive statutory protection, meaning that if you file before that date, you are grandfathered under the current Reform and Integrity Act. So that means that things like your investment amount is not subject to the inflation that could happen on January 1st, 2027. And it's also not subject to reauthorization. With the EB-5 program, there's typically a expiration to the EB-5 program that has to be renewed by Congress before it expires, or by the time it expires, or sometimes even after it expires, Congress does renew it. Right now, the expiration of the Regional Center program is September 30th, 2027. So what that means is that if you file before September 30th, 2026, if the program expires in September 30th, 2020, it's not reauthorized a year later, you're still grandfathered in. It does not affect you. However, if you do apply, let me just go to the next slide, just to let you know, if you do apply after that time, then you don't have that protection, even though the EB-5 program doesn't expire until September 30, 2027, you are still subject to any kind of changes in law that happen within that year. So it's important to consider that deadline. Now, keep in mind, this is only for the regional center programs. These deadlines are not the direct investment. If you're going to be investing into your own business, in a rural area, for example, you're putting the $800,000 in and you're going to be operating that business yourself. It's not a regional center. It's a direct investment. Then this does not apply. That is still a program that is ongoing and does not have an expiration to it. Okay, but even with grandfathering, you want to be sure that if you're going to try to apply before September 30th, very important to make sure your record for source of funds, path of funds is very, very strong. A weak source of funds could cause, again, a denial of your application. And then, you have to start over again. So it does not hold, and also does not hold your position in queue if the category retrogresses. So even if you file before September 30th, If the visa queue retrogresses while your application will still be processing, it does not, you have your priority date, but it does not mean that you're not still subject to that visa queue as well. So it's very important to make sure that you don't rush a filing, make sure it is airtight as much as possible so that you can be sure your priority date is maintained and you also have the greatest chance of success for your application. So key takeaways for that we want you to take with you today. If you're going through the regional center, as I mentioned, the project's I-956F status determines how quickly your application is processed. So make sure that your regional center has done what it's supposed to do in terms of its filings. The current Visa Bulletin category is a processing pace. That doesn't mean that there's not going to be retrogression. It could be because there's a lot of applications that are behind that queue. Third, the proposed rule determines what is probably going to happen, and we don't know the effective date because, like I said, it's proposed comment. Probably it would be no earlier than the end of this year before it actually is enacted. But keep in mind, right now, it doesn't change anything about your filing and your process as well. But also keep in mind that that 2-year sustainment rule that is proposed is very favorable, and it actually is pretty much being used today. It's just being formalized into the rule, so that's really good. But the deadline, while the deadlines are real, you want to make sure your petition is the best it can be before filing. All right, so we are now at the end of the presentation. I will look to see if there's any questions. As again, please be sure to put your questions into the chat and make sure you ask your questions in a general terms, avoid any personal details or information as well. So I do see there's one question here. Someone said, you just mentioned 4 years potentially for approval of the I-56E for rural ROW. No, I didn't mention in the past it could have taken that long. Currently with the priority queue, according to what we see now, it should be faster for the I-526E within a year or less. 8 months is what they're telling us now. But that doesn't mean that what I was saying could take 4 years or more to actually get approval of the green card, depending on the processing, the Visa Bulletin and other I-485 processing as well. There are a lot of other variables beyond the I-526E approval. Another question is the 10 full-time jobs should be created and maintained for how many years? If I invested in a coffee shop or a restaurant in rural area, how many years should there be for 2 years? Now, typically, it's usually over a 2-year period that they expect to see those jobs created and maintained as well. Because keep in mind, especially for a direct investment, which is what it sounds like you're doing here, or you're discussing here, you are expected to, once you get approved for now, if you've already created those jobs will be counted. So for example, if you've already made the investment and you filed and you show you already created those jobs, they're going to count those jobs and you have already met that requirement. But if you haven't done that yet, then by the time you have to show a proposal of how you're going to meet those 10 job requirements, then if you're approved for the conditional residence, when you go back for your I-829 to remove the conditions, you will have to show that you did create those 10 jobs over that 2-year period after you receive conditional residence as well. And then the other question, part of the question is how many years? Oh, that's the question. Okay, thank you. You're welcome. What are the usual attorney fees for EB-5? What is the total funds needed to acquire from start to finish? Well, I can't really say the total because one variable there is the regional center. If you're going to use a regional center, then there's administrative fund administrative fees that you have to pay to them, and that varies depending on the regional center. If you're going to do a direct investment, starting your own business, then of course you don't have that administrative fee. You just need the amount of investment of 800,000 if you're in the rural or high unemployment area. For attorney fees, our fees depend on what type of investment you're doing as well. For us, it's 12, and we've pretty much kept this fee for the same 10 years. It's 12,500 if you are going with the regional center. If not, it's if you're doing direct investment, then it's 15,000 for attorney fees. Now, also keep in mind, you also have to look at the application fees as well, which does change. I don't have them off the top of my head right now, but there are additional fees, and they're pretty hefty as well. You're probably looking at least 15,000, depending or more, depending on the size of your family as well, if you're doing adjustment of status. Oh, and also, those fees I just mentioned were related to the EB-5 I-526E petition or I-526 petition. Does not include adjustment of status fees. So our fees for that is 2,500 for each adjustment of status application as well, plus application fees. So I think, oh, I have one. Oh, you're welcome. All right. So I have time for one more. If you have any questions, I'll give a few seconds for anyone to type into the chat for their question. While we're waiting, please feel free to schedule a consultation. You can do that by calling us at the phone number on the slide or emailing info@badmuslaw.com, or the easiest way is to go to our website and fill out our contact form, and that will get you through to one of our client service associates who will help you to schedule a consultation. Okay, well, I want to thank you all for attending today. And hopefully this has been helpful. So many of you have said it has been, so I appreciate that as well. So thank you all again for attending, and have a great day.